Hello, everyone. This is Sarah Diaz from the California WIC Association. Thanks for joining us today for our webinar. I'm really happy to have Robbie Gonzalez-Dow from the California Breastfeeding Coalition and Julia Parrish from Legal Aid at Work here with me to put on this presentation for you guys. So I just wanted to talk about a few housekeeping type things before I turn it over to them. Everyone is in mute mode right now to sort of keep it quiet. If you have a question going forth, which we hope you will because we would like it to be as interactive as possible, if you raise your virtual hand, I can unmute you if you have audio, or if you'd rather type a question into the question box, I can read it as we go along if you don't have audio. The whole webinar will be recorded if you want to look back on it later. And I think that is about it. Oh, I'll also make Julia's slides available to everyone afterwards as well. So I will go ahead now and turn it over to Robbie.
Thank you, Sarah. Welcome, everyone. I'm Robbie, the director of the California Breastfeeding Coalition. And our vision is that there are no barriers to breastfeeding in California. Our mission is to improve the health and well-being of Californians by working collaboratively with state organizations, government, and local breastfeeding coalitions. And we do this to protect, promote, and support breastfeeding. And today, we are currently part of a collaborative improvement in innovation network. They call them COINs. And this is a California COIN that is focusing on lactation accommodation. And the collaboration includes the California Breastfeeding Coalition, the California WIC Association, and the California Department of Public Health Maternal, Child, and Adolescent Health Program and the WIC program. And our goal is to build capacity of individuals and organizations working directly with communities that have low breastfeeding duration. And we want people to be able to support workplace and school lactation and reduce related infant feeding disparities. We also want California parents who return to work or school after giving birth and who choose to breastfeed or provide human milk to equally and adequately be accommodated. So today's webinar on lactating employees' workplace rights is the first of a webinar in this series. And the next webinar will be in July, and that will have a focus on social media and outreach for World Breastfeeding Week and breastfeeding awareness in California. So it is my pleasure to introduce Julia Parrish. Julia is a staff attorney with the Work and Family Program at Legal Aid at Work. And she assists with the project helplines and provides legal advice, know your rights workshops, and direct legal services for workers struggling with family and medical crises. And Julia she's very passionate about workers' rights and the rights of lactating women in the workplace. And she's a mom of an almost 2-year-old and soon to be expecting or to have her second baby. So I welcome Julia.
Thanks, Robbie. Thanks, Sarah. So I'm just switching this over to my screen. Hopefully you can all see the slides now. Yeah, so I work at, okay, great. See if I can advance them. It's not working. Okay, I figured it out. So hopefully today we're all going to talk about ways that you can educate your patients and clients about their workplace rights. We're going to talk about real examples from situations that you asked questions about in your registration and also that we've come across in our work to talk through some solutions and ideas. I'm going to do my best to explain the relevant laws to you, including paid family leave and job protection, which aren't sort of squarely lactation laws, but they have a big impact on people's ability to breastfeed their children. By way of background, Legal Aid at Work is a nonprofit, and our work and family program is designed to help people meet both the needs of their families and their employers and keep access to their jobs and income through various stages in their lives. And we offer free legal advice and information. We have helplines. We represent people. We also engage in some policy advocacy and outreach and education that Robbie's going to talk about at the end. Pardon me, I'm sorry. So really briefly at the beginning, I wanted to talk about rights related to pregnancy leave and parental bonding leave before we get to specific lactation rights because they are linked, and I know that it's an area of a lot of confusion for people. I'm going to go through this part quickly, but Sarah's going to send you the slides, and we also have additional information about these things on our website, and you can ask questions about them at the end. I just want to make sure I leave enough time for all of our lactation scenarios. So there's sort of one main concept that would be wonderful if you could walk away with, which is that when we talk about maternity or paternity leave, there's actually not a single coherent legal concept that encompasses that thing. We think of a chunk of time to be with your new baby, but the law treats it differently. The law has specific requirements for what's called job protected time off, which means that, your employer can't take any sort of negative employment actions against you, and they have to give you the time off of work. And then there are separate laws that apply to getting paid while you're not working. And unfortunately, those have different eligibility requirements, different time periods for duration. They're administered by different systems. So ideally, someone can have both at one time, but it's important to know that there are different things and that getting one does not necessarily mean that you will get the other. We're going to go over some examples of that. So first, in California, we have a very protective law called pregnancy disability leave, and it provides people with up to 4 months of job-protected time off. So that means they can't fire you. They have to give you your job back. It's up to 4 months because this period of time only applies to the time that you're actually disabled by pregnancy and childbirth. So most people are entitled to less than 4 months because in a typical pregnancy without complications, you are considered disabled by pregnancy 4 weeks before your due date, and then 6 weeks after if it's a vaginal delivery, or 8 weeks if it's a cesarean. That's sort of a standard period of time, and it can be adjusted based on an individual person's medical need. That's why it's up to 4 months, but without an exact period of time. And this can be confusing because it's different for everyone, basically, but it's really meant to match your body and what's going on with your recovery. So it's flexible based on different pregnancies and different people. Again, that's job-protected time off. And the way that people get paid during that job-protected time off is through state disability insurance. State disability insurance is a wage replacement benefit, and now in 2018, the amount of wage replacement has actually gone up. It used to be 55%, and now it's either 60 or 70%, depending on your income. For the lowest income workers, they get 70% of their wage replacement back during the disability period. And again, this disability period varies for everyone. It depends on what your doctor says, but it has the same sort of standard 4 weeks before and then 6 weeks after or 8 weeks after if there aren't any complications. And this money comes from the state. It doesn't come from an employer. So people will sometimes apply for this and think that they have protected their job, but your employer doesn't actually know anything about this. They don't have the right to approve or deny a claim. They might not know that you've applied. So there's you have to protect your job separately from filing for these benefits by turning in a note from your doctor to your employer, which can be confusing because you have to do two different things. Then once you've recovered from childbirth, let's say, for example, 6 weeks after you deliver, that's when your pregnancy disability is over and when your parental bonding leave can start, assuming that you are eligible for bonding leave. There are two laws before this year that provided for bonding leave. One is the California Family Rights Act. There's a federal version called the Family Medical Leave Act, which many people have heard of. In California, it's sort of more protective to use the California version, but they're very, very similar laws. And that provides 12 weeks of job protected but unpaid leave to bond with your new child. But there are 3 very strict eligibility requirements to be able to take those 12 weeks of guaranteed time off. You have to have been with your employer for at least a year. Your employer had to have at least 50 employees within a 75-mile radius of your work site. And you have to have worked 1,250 hours in the year before your leave starts. And you have to meet all 3 of those eligibility requirements. It's not just one. So it's all or nothing. If you meet all 3, you get 12 weeks. If you don't meet them, you aren't entitled to any job protected time off to bond. And those eligibility requirements exclude over 40% of the workforce, and they disproportionately exclude low-wage workers, which is a significant problem. We want people to be able to bond with their new child, to establish breastfeeding, to engage both parents and caregiving. So this is a really important law and it's very protective for people who qualify, but not everyone qualifies for this. But there is good news because in 2018, a new law went into effect in California called the New Parent Leave Act. And basically what this law does is lower that employee threshold, the number of employees that have to work at the company, from 50 down to 20. So now, starting in 2018, people who work for companies that have at least 20 employees, instead of 50, only 20 within 75 miles of their workplace, can have 12 weeks of job protected time off. So this is a huge increase. It's going to cover another 2.7 million Californians who are going to be eligible for, or potentially eligible for, new parent leave. And I guarantee you that many of those workers and many of those workplaces do not know about this change in the law, because it is a pretty significant change from the 50 employee threshold. So this is a great opportunity for you to help your patients learn about a right they may not know they have, and their employer may not even realize. They may be informing them about the old eligibility requirements instead of the new eligibility requirements. But you all should know that it now applies to employers with 20 employees instead of 50. So that's job protected time off, 12 weeks to bond with your new baby. But people need to get paid during that time. In most cases, your employers aren't required to pay you when you're not working. But the state has a program that's very similar to disability called paid family leave. I'm sure many of you are familiar with paid family leave. Similarly, the wage replacement rate for paid family leave went up in 2018, so it's now 70 or 60% instead of 55. The other important thing about paid family leave that changed in 2018 is that we eliminated the 1-week waiting period. It used to be that if you were going to collect all 6 weeks of your paid family leave benefits, you had to actually take 7 weeks off from work and basically suffer an income loss for that first week. And that's no longer the case. You can now get paid starting effectively day 1 of your paid family leave for bonding or to care for a seriously ill family member. And that's going to be really helpful, we hope, for low-wage workers to access this benefit. Because a week without pay is too long for a low-wage worker to have to wait to be able to access these benefits, and it was keeping people from being able to use them. So one important impact of paid family leave in California has been that it doubled the median duration of breastfeeding for all parents who use it. I think largely because they were able to take more time off from work, because taking time off from work without access to pay is not practically possible for a lot of workers, particularly low-wage workers. So having this wage replacement program and having people be able to access it is really important in supporting people's decisions to breastfeed and giving them time to establish that relationship. And the awareness of paid family leave in California is actually very low. So the more education and outreach we can do to people that this benefit exists, and the wage replacement rate is now higher and there's no waiting period, so it's a more attractive benefit than it used to be in the past, can help help inform people about their rights to take this benefit. So just as a summary, I know that was like a ton of information, but in 2018, there have been two big changes to the laws that are important for people to know about. One is that more people are going to be entitled to job-protected leave to bond with their new babies. The law calls it bonding leave. I call it bonding leave. Probably people just talk about it as maternity or paternity leave. More people are going to be eligible for that, and more people can now get more money while they are taking that leave. So that's some really great news for working families in California, and we are hoping you can all help us spread the word so that people know.
Julia,
yeah.
I just wanted to see if there were any questions just about that part. I just had one. The new Parent Leave Act, and it lowered the threshold to 20 to 49. Do they have the same rules to access that? That was just one thing that was unclear to me.
Yeah, so you have to still have worked for your employer for at least a year, and you still have to work at least 1,250 hours before your leave starts. So the other two eligibility requirements are the same. It just will now apply to smaller employers.
Great, thank you. And just to let everyone know, you can access the webinar slides right now on the panel. There's a little icon, like an Adobe icon, and you can download them now, and we will also have them available after the webinar. Sarah, have you identified any other questions?
Yeah, so there's a question that's, what is the direct starting process to apply for the various leaves?
Yeah, so to apply for leave from your employer, you just have to notify them and turn in a note from your doctor. Usually, sometimes some employers have their own sort of form that they request that you fill out. And you want to do that at least 30 days before you anticipate your leave will start. Sometimes babies come early and things happen, but at least 30 days from what you think the start date will be. That's when you need to give your employer a note talking about requesting leave. For the benefits for the pay that comes from the state, you can't apply for those until you actually start your leave. So you can't apply for them early. You should just apply for them after your leave starts within 49 days of the first day of your leave. So the state, unfortunately, won't let people plan ahead for receiving that benefit. That's a great question. And again, for the money benefit, you apply directly to the state, which is the EDD. The website is edd.ca.gov. People can also turn in paper applications, but they are processed much more slowly than online applications. So if possible for people to do online, that will get them their benefits faster. Now we're on a chart that's supposed to illustrate how some of these rights work together. So if you look above the line, you see the money is coming from state disability insurance, and then the job protection is coming from these other laws. The important part about this slide is that you see that this is somebody who gave birth, right? And she is taking pregnancy disability leave, and then she's taking bonding leave. Notice that her bonding leave does not start until after she recovers from childbirth, right? So that 12 weeks to bond with her baby doesn't actually start when her baby was born, and it doesn't start when she starts her leave. It starts only after she is recovered from childbirth, which is a unique thing in California and is something that many people don't understand, but it actually means that you have much more time than you would otherwise to bond with your child. So that's an important thing for people to know. Bonding leave, in most cases, unless somebody has a very long recovery from childbirth, doesn't start until after you recover. They shouldn't overlap. And then again, you get 6 weeks of partial pay from the state during that time. This is what it would look like. Yeah.
A question on that. Of the 12 weeks that an employee is entitled to take, can the employee choose to take vacation and sick time for the 6 weeks that are not paid through PDL?
Yes, if you have that available to you. So like I said before, not everyone is going to be eligible for that 12 weeks of bonding time because, again, you have to work for a company with at least 20 employees and you have to have been there for a while and worked a certain number of hours. So in that case, you're still entitled to the same sort of pregnancy disability leave as long as you work for an employer with at least 5 employees and disability pay. But when you recover from your childbirth at 6 weeks postpartum, you're going to get a form saying, hey, did you know that you're entitled to 6 more weeks of paid family leave? Check this box and we'll send you some more money. And a lot of people do that and they don't realize that that does not automatically protect their job because it seems very official and it seems very sanctioned. But not everybody who can receive paid family leave is going to be eligible for job protection. And so what we suggest to people in that case is just they speak to their employer and ask their employer to agree to give them the time off. And then if the employer agrees, send a little email or text or something confirming in writing. Like I said, the employer is in most cases not paying you anything during this time. They're just allowing you the time off to access the benefit that you have paid for to the state of California. So many times they're willing to be flexible. You can also negotiate, like you can take 2 weeks now and then take 2 weeks when the baby is 6 months and 2 weeks later. It's a flexible benefit. You just have to use it up before baby turns 1. But the main point here is to not assume that everyone who can receive paid family leave is automatically going to have their job protected. And like I said, most of the time people will agree. I tend to hear about things when things go terribly wrong only. And so I've talked to so many people who have lost their job without realizing it because they don't understand that receiving paid family leave doesn't have any sort of binding effect on their employer. It's a benefit that comes from the state and it doesn't have to do with their employer. So that's it for what I was going to talk about in terms of leave and bonding, because I know that we have a lot of questions and things to get to about lactation. I can take questions now about this, or we can do questions at the end. Also, just know that we have all of these resources on our website, including videos and fact sheets and stuff that goes into more detail. And people are also always welcome to call our helpline if they have questions. So I think I'll move on to the lactation part, but we can always come back and answer more questions about this at the end. So now you have helped your patients and clients get paid family leave and take time off from work, and they've established this strong breastfeeding relationship, and now they are going back to work and want to continue to pump while they're at work. There are sort of 2 main laws and then a San Francisco law as well that allow for break time and space for people to pump milk. Both of these laws are pretty sparse. They just are a simple few lines in the basically in the labor code that says very simply you have to have break time and space, not a bathroom, and then the space has to be private. And that leaves a lot of people frustrated because it's not really broken down into exactly what that means in every situation, and that can be hard for people to figure out and navigate. But the reality is just that these laws are written that way, and normally when you have a law, there's other sources of authority for what the law means. Like if you have a lawsuit and a judge makes a decision, you can use that to interpret what the law means. These laws are very rarely enforced, so there's not a lot of case law about them. And so we have to sort of just use our most reasonable interpretation of what the text actually says, which is sort of an annoying lawyer answer, I realize, and I apologize for that, but that's just the reality we have with these lactation provisions. One question that comes up a lot is about sort of when these laws don't apply. And the simple answer is that in California, they really always apply. There are very few circumstances when an employer would not have to grant a lactation accommodation request. So the federal law says that with employers with fewer than 50 employees can deny it if it would be an undue hardship. But the California law doesn't have any sort of employee number in there. So, and what the way that we interpret laws is that the most protective law is the one that applies. So when California law is more protective, we get to use that standard. So there's no sort of number of employees that you can say, like, oh, I have fewer than 50 employees, this would be hard for me. That's not something that exists in California. The other thing the federal law does is, has an upper age limit of 1 for granting the accommodations, and California does not contain an age limit for the baby. So again, because the California law is more protective, we can use that as the standard here in California for employees, except for federal employees. Federal employees are only subject to the federal law, so it's a little bit different. The one other difference is that the federal law applies only to people who are paid hourly or people who are not exempt from overtime provisions. But the California law, again, applies to everyone. So it's the more protective law. There's another law that allows people to take it's the same law, actually, as the pregnancy disability law that allows for other sorts of reasonable accommodations and to be free from harassment and discrimination and everything like that, retaliation because you are breastfeeding or pumping.
Julia, just one question about the federal law. So let's say somebody works for an employer that's fewer than 50. The federal, they're an hourly worker, and the employer says, it's an undue hardship, we don't have space. But the California law does apply to her also. In that case, then if she doesn't agree with a decision to say it's an undue hardship, then would she just go through the complaint process at the federal level?
That's a great question. That's an option. She could do that. It could be that the employer doesn't know that there's a California version of the law as well. So even pointing that out can be helpful, just to alert them of their different requirements. There are a lot of different requirements, and sometimes even well-meaning employers don't understand what their obligations are. And that's not to say that in every situation, applying the California law will get the result that you want. But I do see people sort of misunderstand that the federal standard of 50 employees is the standard in California, and that's not what it is. So just explaining that standard is different. There's other ways of advocacy, like submitting something that people, if an employer is saying this is too hard for me to do, I couldn't possibly do it, employees very often have a good sense of what would actually work in the situation, right? They understand their workplace, they understand the space and the workflow and all that stuff. And so I usually suggest to people, well, what would your solution be to this situation if they're saying this is a problem? And can we suggest things that will show them it's really not a big deal and they can do it? So writing down some of those ideas and submitting them is a good sort of practical step too. But yes, you can also file a complaint with either the state or the federal agency, and we can talk about how that would work.
Okay, thank you.
So we have...
Sorry, there's a couple questions if we can get those before we move on. One, I don't know if this maybe got covered, but it just says, can you please repeat your comments about hourly employees?
Yes, the federal law for lactation accommodations only applies to people who are paid hourly as opposed to people who are paid a salary. It calls them non-exempt workers, but what that means is non-exempt from Section 7 of the Fair Labor Standards Act, which is basically says who gets overtime and who doesn't. So the federal law technically applies basically to people who are paid hourly and who are therefore entitled to overtime pay. But the California law applies to everyone. So it doesn't matter whether you're paid hourly or not, you have the same entitlement to lactation accommodations. So that's just another place that the two laws are different, and that sometimes people get confused because they think that the rights only are for hourly workers, but they're not in California.
And then one more, Have you heard of any employers being granted an accommodation exception, and if so, which company and why?
No, I have not. And the sort of the idea of being granted an exemption is not really the way it works legally. These are defenses that are available to employers. So what would happen as a practical matter is like an employee would come forward and say, I'm requesting an accommodation. The employer says, no, I can't because of X, Y, and Z. And if I am the employee and I just think those reasons are not persuasive or genuine, then I would file a complaint, and someone, either a judge or a jury or one of these government enforcement agencies, would decide whether those reasons, those defenses that the employer raised, are real and really meet the standard. And the standard is pretty high. The standard for undue hardship is pretty high. It's not something that like this would be inconvenient for me or this would cost me some money. That is not going to meet that standard. That's not enough. And so there's no way to sort of preemptively say that you are not subject to these laws. You are subject to the laws, and if you're trying to say that you don't have to provide the accommodations, you have to prove why. And it's a sort of a case-by-case thing, and it depends, again, on the individual circumstances of the situation.
And somebody asks, and I think you might get to this, but are there laws for students?
There are laws for students. I'm not going to cover them in this presentation, but there are definitely resources and sort of similar type provisions for students. Robbie has a bunch of them on the website. I don't know, Robbie, do you want to talk about that?
We will cover them on another webinar, and there are resources on the website. Yeah. If you go to californiabreastfeeding.org and there's breastfeeding rights, there's a section for students. I'm going to go ahead and get into the case study. So Lisa has a 4-month-old baby. She is preparing to go back to work and wants to pump. She works at a busy restaurant without a staff break room. There is a storage closet with cleaning supplies and a small office the manager uses to keep files. So what are Lisa's rights regarding time and space to pump? If you want to put in the chat, you can. We're going to talk through some of these, and but Julia will describe some of these also. Do you want to do just the first one, Julia?
Sure. So as an employee in the state of California, right, she has the right to reasonable break time and a private space that is free from intrusion for her breaks. The question is sort of, I think the next one is really the meat, is where can Lisa take her lactation breaks? What do you all think?
If you can put in the chat, your ideas in the chat box. Take a few seconds. So where do you think Lisa can take her lactation breaks? And are they paid breaks? As people are doing that, Julia, are they paid breaks?
Yeah. Oops. Shoot. So they are often paid breaks, but it depends on sort of the way that Lisa is using them. There are labor laws that require employees to have break time in general, regardless of whether or not you are lactating. And so most people use those break times, and those break times are paid. And most people use those to pump during their breaks. If you need more time than you're entitled to under the law, which again most people do, then your employer doesn't have to pay you for that extra time if they choose not to. So if you are entitled to a 10-minute break and you are taking a 30-minute break, technically your employer doesn't have to pay you for that last 20 minutes. Again, as a practical matter, I don't see this happening, but I did hear from several of people that sometimes they hear from people that this is happening. So an employer could make you clock out if for the rest of your break if your breaks are longer than 10 minutes.
And
but
by
it's sort of
law,
an administrative nightmare for them, so usually they don't do it.
and by law, because some people have 10-minute breaks and some workplaces have 15-minute breaks.
The law defines the amount. If your workplace gives you more than the minimum required amount, then they should let you use that on an equal basis as other employees, right? So they can't say that, like, because you're using your break to pump and they're giving you 15 minutes, that extra 5 minutes is not paid, because they would be treating you differently in the way that you use your break time than like another employee. And that's sex discrimination.
So some folks are typing in that she could use the office with a sign or a lock. Somebody asked, are the files confidential, which I guess is a good question. Someone else said, this happens all the time. My clients tell me they are providing a place to pump. I'm not really sure what it means. I have some clients go to their car to pump.
Yeah, so I think those are great ideas, like use the office, put a sign up, put a lock. What if the files are confidential? Then what should we do?
Make sure they're locked.
Yeah, put them away.
File cabinet.
Yeah. So it's, I think one of the main points that I try to that is that this is, all of these problems are almost always things that, logical humans can overcome if they just put a little bit of effort in. And so maybe the manager really does use her office, and that's something that happens, and so they can figure out a schedule when it would work for them to not be in the office. If there's stuff that she can't leave unlocked in the office, then put that away before Lisa goes in there to pump, and buy a locking file cabinet or something like that. So none of these things are insurmountable problems, even though I know that you hear and I hear that they're offered as sort of excuses that why this won't work. All of them are very overcomable, right? So it's not an undue hardship to get a locking file cabinet, right? Or to be out of your office for a certain period of time, a couple times a day. Those are things that are sort of reasonable and should be manageable for anyone to do.
So if Lisa's boss says that she can't provide her a space, it's an undue burden, and then we're sitting there and Lisa's in front of us, and we're in a counseling session, what do we tell Lisa? She may be afraid to tell her boss that they have the incorrect information.
Yeah.
Feel free if there are people to raise your hand if you have dealt with this, if you have solutions also. What is some of the advice that when you get people who call the helpline?
Yeah, so for this is one of the situations where, we would, it depends again on what Lisa wants, how Lisa wants to approach the situation, but this might be a chance to suggest some concrete things to the manager about why it could work, respond to whatever concerns they're raising. So say, why do you think it's an undue burden? And then we can address those things and show why it isn't. Okay, well, here's all of the solutions we could do instead. All of these things would work. Can you do that? If not, then, Lisa can take a next step of filing a complaint. Or one thing we do here at Legal Aid is we'll often send what we call a demand letter on behalf of people, which basically says, here's what the law says. This is what you told Lisa. That's in violation of the law. Please fix it now. And then hopefully that can sort of spur some action. But I think, again, a practical first step is really sort of trying to problem solve and maybe giving, the manager access to some of the resources that we use, the fact sheets, the law, the videos about how to make lactation work in different kinds of workspaces, Some people just don't confront this issue very much and feel overwhelmed by it, and so sort of want to shut down, and they're not allowed to do that, obviously, and that's harming Lisa, but sometimes with a little bit of prodding, you could get them to do the right thing. And I would also tell Lisa to sort of document. It also helps Lisa's case in the future if she has some of this communication in writing where she's like showing that like it's really possible. She's really trying to make it work, and they are not being reasonable.
So there's a couple more questions. How about someone working in the field? That's the first one.
Do you want to cover that now, Julia, or want to go to some of the other examples, and then we could cover that at the end?
Robbie, do you want to do that one? You have better examples than I do for that question.
Yeah, I'm not sure exactly specifically what they're wanting about the fields, but we do have some good examples so they can, in terms of privacy, there's, it's reasonable. So we've identified some tents that they can set up, and we do have farms that are doing that where they do provide privacy. The employees, her own car. Some are driven out in buses in providing screens. WIC programs have done that where they've provided shielding for the windows. So if they want to turn on the air conditioner also, or the company car. Those have been some of the solutions that moms themselves who work in the fields have come up with. And it's really, it works better than when you let the mom choose what works for her instead of the employer saying you have to pump here or there out in the field. And then they get, they have breaks also.
Another question is, do part-time jobs and full-time jobs offer the same break time? And if part-time jobs, if part-time, can they still have the breastfeeding break time?
If you don't work for at least 4 hours a day, you aren't entitled to a break time under like the rest period provisions, which are like the regular break time provisions for all employees, but you would still be entitled to lactation breaks if you needed them.
It just
and for the farm worker question, again, it's not that a farm worker has substantively different rights. It's just that the solution is going to look a little bit different for her, right? So again, the laws apply to her in the same way. It's just what does that mean in that particular set of circumstances. And again, the laws apply to workers whether they're documented or not documented, part-time, full-time, paid in cash, not paid in cash. These laws are covering everyone who is a worker, basically. So what about Monica? Robbie, do you want to read about Monica?
Yeah, and thank you for those questions. Monica works as a housekeeper. She's returning to work after having her baby and wants to know her rights to pump. So what are Lisa's rights regarding time and space to pump? Are they different than other employees? Why or why not? And what if Monica is undocumented?
I'm sorry, there's a typo there. Monica's right.
Okay. So her rights regarding time and space, and I just heard you say, regardless of the work, these laws still apply to her, regardless of the job.
Yeah, so she's probably maybe she's the only employee of this particular employer, right? If it's just like a private person who has her come to their house and do caregiving or whatever it is, she might be the only employee, but she's still an employee, and she's still covered by these provisions. So again, the way it might look for her might be a little bit different, but her rights are sort of substantively the same as if she worked in an office building or anywhere else. And then I answered this as well. And if she's not documented, that doesn't mean the laws don't apply to her. The laws apply to her in the same way. She might be more scared to try to enforce them or face other sorts of barriers. But from the legal perspective, she still has these same rights. She still is an employee.
Sarah, any other questions?
Yeah, there are some more questions on breaks. So somebody says, regarding breaks in our large hospital facility, we have a lactation room. It is up to 7 minutes from some units. Is this travel walk time part of her break? Second, in 8 hours, we are allotted one 30-minute break, clocked out and in, and two 15-minute breaks, which can be combined. Is the walk time above these assigned times?
So the first question about it takes you 7 minutes to get to your lactation room, the lactation laws don't address this exactly, but the rest break laws do. And your rest break is the net time that you have, should be your rest break. So if it's taking you a lot longer than that, that's not your break time yet, right? Your break time doesn't start until you can start your break time. The second question about whether, I think that it's about whether the lactation time can go over and above what you're otherwise allotted by your employer, and the answer is yes, absolutely. Again, this is a separate right than your break time. So if you need to pump for longer than the amount of time that you're given during your normal break, you have the right to do that. And if you need to pump more frequently than your normal breaks are scheduled, you also have the right to do that.
Another question on breaks is, so breaks for pumping are not paid by the employer if the employer does not want to pay. Is that correct?
If they exceed the regular break time, then yes, that is correct.
Another question on Monica. If Monica is undocumented and a labor contractor, is she still covered by the law?
Okay, so if she's undocumented, yes, she's still covered. If she's an independent contractor, then no. People who are truly independent contractors are not considered employees, and so no employment laws apply to them at all. But most people are not independent contractors, sort of regardless of what you're called by your employer. We could do a whole many-hour webinar about what an independent contractor is. But if you are truly an independent contractor, you are not covered by these laws. But don't assume that you are an independent contractor just because some employer told you you were. You should actually look into whether or not they're controlling your work. And we have resources about how to figure it out on our website. And I can help you if that question comes up for someone you're helping. That would be a good time to sort of call the helpline and maybe get some more advice.
Julia,
sorry, do we want to keep going on questions, or should I hold a few more?
This just has to do with contractors. What we do see in agriculture is there's a contracting company that then they hire everyone and then they contract with the farm. But so
that's No, those people are employees of the subcontractor.
Right. Okay.
Just because there's a contract doesn't mean that you're an independent contractor. Yes, this is another sort of very obnoxious lawyer moment where it's it really depends on the sort of work you're doing. But the existence of a lot of people contract out work, but you're still an employee in that situation.
Just one thing on this, what I've heard from some people, they're not sure if somebody's working in somebody's home, do they have the right to ask to pump in somebody's home? And so the answer from this is yes, they do have the right.
Yeah, if you are working in someone's home, then their home is your workplace. I mean, it's also their home, but it's also your workplace. So you would have the same sort of workplace rights.
Why don't we go to the next one and then see if those apply, Sarah?
Sure, and hopefully we have just a little bit, and these slides I'm going to skip over, but basically they show that, and I'm sure all of you know, there are real disparities, and a way to address the disparities in breastfeeding rates effectively is by having lactation accommodation. So this is something we know really works and can really address a problem that exists for many workers. I think it's tricky to enforce, and people are reluctant to ask for these things because they're afraid of retaliation. So again, I'm so happy to be working with all of you and all of the work you do to help sort of arm people who want this to make it possible for them. But we can talk about more case studies, and then we're, I think, almost done. We can go to questions at the end.
So Lisa is having trouble getting the lactation breaks she needs. The manager is often on the phone in her office when Lisa needs to pump and makes comments about the frequency and length of Lisa's breaks. She says that Lisa is taking too many. In addition, no one is available to cover her tables during her breaks. What advice do you have for Lisa? And what if the problem persists? Yeah, I've actually had someone call and experience this, and she said, I'm doing a great job providing milk for my baby. I should not have to use formula, and my workplace should support me. And it was really putting her in a situation where she was feeling that they were, like the manager using the office, kind of doing it on purpose so that she wouldn't be able to pump.
Yeah. So if the manager is in the office, if the manager's office is the place that's supposed to be the lactation space, right? And we all know that, nobody has to have a permanent, beautiful room if that's not the way the workplace is, which is fine. But if they're going to use the office as a lactation space, that means it really has to be the lactation space when Lisa needs to use it. That's sort of the trade-off. Like if you don't have a dedicated lactation room, that's okay, but you still have to make a space that is private and free from intrusion available to Lisa when she needs it. And so this space is not really private or free from intrusion, right? The manager is intruding on this space. It doesn't matter that sometimes the space functions as the manager's office. The point is, like, for her lactation breaks, that space is a lactation room. And so it should really be for her to use. Otherwise, they're violating that space provision. And then in terms of the length and frequency of her breaks, this sort of goes to the previous question of that I think is really a benefit in the California law, but sometimes people get confused about, is like, the lactation provisions don't say you get half an hour or you get 10 minutes 4 times a day. It says you get reasonable time to express milk. And what that is different in different situations, right? Like if Lisa has a premature baby that's in the NICU and she's trying to pump up her supply, she might need to pump much more frequently than somebody whose baby is 11 months, right? And that person maybe pumps once a day. It's the law sort of intentionally doesn't define a particular number of breaks or length because the intent is to recognize that that's going to be different for different women and for different babies and at different times of life. So the real question is what Lisa is doing, is it reasonable? Is that really what she needs to do for that situation, and how to help her make that argument. And I think that's, she's not painting her toenails and texting her boyfriend. Like she's in there, she's pumping milk and she needs to pump milk X number of times a day to keep her supply up. So that's another thing that can be just sort of a practical way that service providers can help, is sort of explaining the way that works to employers, like even just a little note saying Lisa needs to pump this many times a day. It usually takes about this long. And that, if she doesn't do that, she's going to lose her milk supply, which, again, as employers don't understand that. And so it might help explain to them that she's not sort of being abusive of this system, but that this is a real sort of medical need. And then if they're not providing her anyone to cover her tables during her breaks, again, they're not really providing her with the time off. It's sort of the same question as the office, is like that you're fake providing her with that. You have to make it really accessible for her to use. And if her problems persist, you can have her call us, or she can file a complaint with the agency, and she should sort of document the problems that are happening at the workplace in the way that she feels comfortable doing. If she has an HR department, like if this is a big company that has like a central HR department, it's a really good start to sort of make a complaint there, because those people can often explain duties to like mid-level managers that they don't understand, but a lot of places don't have an actual HR.
I think even too, just as educators, lactation educators, advising to try to pump at the same time every day, and then it's predictable, and that will help to maintain their milk supply. Some of the calls I get that call the coalition, some moms aren't aware, they just haven't had that education of lactation management, and that pumping at the same time every day is actually beneficial for them. And that really helps an employer too, then to determine when the space is needed, whether it's the conference room, a principal's office, or the break room, or the manager's office when it needs to be used.
Yeah.
So I'll go to the next. Is there the other you want me to go over? The case study?
Maybe we should do, let's do this one.
Okay. Lisa has gotten the time and space she needs to pump, but her manager has cut her hours, saying that she is no longer a productive employee. What advice do you have for Lisa? What is a problem persists?
Right. So what have they done? What has this manager done? They're retaliating against her, right?
Yeah.
For trying to access her rights.
Or they say, maybe you need more time off.
Yeah, they might. They're not going to say I'm cutting your hours because I don't like that you're pumping. Like, it's really rarely say that, but clearly, even if they didn't have this part saying that she's no longer a productive employee, maybe they just cut her hours with no explanation. They're retaliating against her and they're discriminating against her. And actually, the sort of penalties for this can be more severe than for just denying someone the space, because this can be sex discrimination. So it's important for her to sort of understand that she shouldn't be retaliated against for exercising her rights. And if she is, she has separate rights against her employer for doing that. And that would be, you could connect her with us, and she can also file a complaint with the administrative agencies for retaliation. Okay, we talked about this at the very beginning, but let's have this be the last one, and then we'll do questions.
Rosa got the accommodation she needed, and now her baby is almost 1 year old. She is worried because she heard that she has to stop pumping when her baby is 1, but she and her baby are still enjoying nursing, and she wants to provide breast milk. What advice do we have for Rosa? And what if Rosa worked in a different state or for the federal government?
So, Robbie, what do you think? What advice do you have for Rosa?
If she's in California, she has the right to continue pumping as long as she wants to in the workplace.
Yeah, I think this is somebody who's like looking at some general fact sheet that's about the federal law, which is why it's confusing, right? But if she were somewhere else, that might be true. But she luckily is in California, so it doesn't matter for Rosa that her baby is going to turn 1. Well, it matters for her, obviously. That's a big deal, but it does not impact her right to continue to pump. So here's where you can file some complaints. If you have to file a complaint, you can call us. We can help you figure out where to do that. On our website, we have all these resources, so please go look at the website. We have videos and other tools.
And the videos are great. You could even show them at, they're short enough maybe to show a clip or one of the videos at a staff meeting. And I also wanted to mention that on the California Breastfeeding Collation website, under breastfeeding rights and work in schools, there is clear instructions also on where to make complaints. But I highly recommend calling Legal Aid at Work or looking at their resources. I use them frequently. Other ways to stay involved. So we do have a current bill right now that is being considered. It's SB 937. And again, you can look on the website under current legislation. And what it is doing is somewhat mimicking what the San Francisco ordinance has done in providing more clarification about time, really about space and what that space should look like, and some other protections for women in the workplace. And we have a breastfeeding action network that you could join, and it's really this group of people if you want to get more involved to address the systemic and institutional barriers to breastfeeding at the policy level. You could go to the next.
Yeah, here's our website and our helpline. And I don't think any of you are lawyers, but if you are lawyers, email me and I can get you MCLE credits. But we have like 2 minutes for questions if people want to do that.
We have a whole lot of questions, so
how about if you want to stay on the line, feel free to stay on the line and we'll go through the questions so that we can have them recorded. And if you need to get off, then thank you for joining us at your lunchtime and learning more about lactation accommodation.
And if you have to get off the line, the recording will still be available later. Maybe you can catch up on questions that you missed. So the first one is, do the laws cover employees at casinos on Indian reservations?
Oh, tricky. Sometimes yes and sometimes no. It depends on the sort of contract they have with the state.
If the company is large and has multiple breastfeeding mothers...
So how could we figure that out, or who could we talk to in the communities where there are casinos?
That's really, really hard to figure out. In general, reservations are often considered sovereign, so it's like a different state, right, or a different country. But some tribes have agreements with the state, and in that agreement, the tribe says, okay, we will abide by the state's laws. But my understanding is that those agreements are different with different entities. So I don't know the answer to how to figure it out.
So I guess I would recommend is you can, as a coalition or local advocates in the area, to contact the human resources and just meet with them. If it's even just sharing about the resources in the community that you can provide to their employees, information about lactation accommodation, or the services at your agency. That might be one way also to then start to share about how supporting women in your community is really important and how you can support them with lactation accommodation, if it's providing information, doing workshops. That's just one strategy I would take.
If the company is large and has multiple breastfeeding mothers and only one lactation room or space, would this violate the law as inadequate accommodation?
I mean, the accommodation is the individual employee's right. So if I am individual employee and there are too many other people using the space so that I actually don't have access to a private space, then maybe in regards to me. But there's no rule that says, like, you have to have X number of spaces for X number of employees. It's really like, if it's working for the employees you have to access the space, then you are meeting your obligations. And if it's not working and some employee isn't getting the space that she needs, then you're not.
In a hospital, can an employee pump in the employee break room, or does she have to go to the designated lactation room?
I don't know. I mean, I don't know that you are entitled to a space that's private and free from intrusion. But if there is another space that you are using that's working, I can't see why that wouldn't be allowed, I guess.
I have heard of one place where an employee working at a hospital wanted to pump at her office. But she shared an office. The other employee was not okay with that. And so she was then forced to go to where the designated space is. And
yeah. So like if you're keeping other people out of the break room or something like that because you're using it for pumping, then yeah, maybe that's a different situation because those other people would still have the right to access that room or like be in their office or whatever it is.
If a labor contractor under a subcontractor, e.g. in ag, works for the company for which the subcontractor is a vendor, would this bigger company be required to provide lactation accommodation, or is it the subcontractor's responsibility?
Labor contractor is not, I don't know what you mean by that term, but the person the entity that is required to provide the lactation accommodation is the employer. So if your employer is the subcontractor, then they're the ones that have to make sure that the accommodations are provided. In some cases, people have joint employers, which is like really like, so you kind of work for the subcontractor, but really you also work for the larger company. In that case, you would argue that they are both your joint employer and they would both have the obligation to do that. There's also a joint employer test. It's sort of like the independent contractor test. You can read more about what makes something a joint employer, or we can talk about it later.
Can an employer implement how employees take time intermittently? For example, have a policy which states that you must take 2 weeks at a time or take all 6 weeks at once?
So I think this question is about bonding leave, and if it is, what the law in California says is that your employer can make you take your bonding leave in 2-week chunks, except for on 2 occasions, which you are allowed to take it in less than 2-week increments. So, for example, you could take 1 day 1 week and 1 day another week, but then after that, they can make you take it in at least 2-week increments if the reason you are using the time off is to bond with a new child.
How many breaks can someone be entitled to have on a day when pumping?
So what do you guys think? Sarah or Robbie?
I think that however many is deemed reasonable and however many they can get a provider to back them up on.
Yeah, I think that's right. It's what is reasonable. And we don't, I mean, obviously you're not encouraging people to be, I mean, they should use only what they need and not more. But if it is reasonable for you in certain situations and it's reasonable that an employer could accommodate more frequent breaks, then that's what you're entitled to.
So somebody asked, when you say contact us, what do you mean? And I'm not sure if that's for Robbie or Julia, but I guess it's useful to know how to contact both of you.
Sure. So for us,
never mind. Thank you.
On this,
I'm just going ahead and reading these in sort of linear order, so some of them have follow-ups. Somebody said they had mentioned that they put their 2 breaks together. This wasn't addressed, but it is not permitted by California labor codes to put 2 breaks together. So I guess that's just an FYI. Does the employee need to provide a storage? I'm assuming that should be employer. Maybe should the employer need to provide a storage for your milk? Like refrigeration?
Not under California law. In San Francisco, they do.
Julia, can you address the 2 break, like it's putting together 2 breaks?
Okay, so it's actually sort of complicated. There are different wage orders that different sectors of employees fall under. And so like some people are wage order 5, some people are wage order 7, and they have different ways that breaks are structured. There's also ways that you can agree with your employer to sort of do things differently. It's a little fact intensive. I would say like for the vast majority of people, you get 2 separate breaks a day is usually how it works, but not always.
So Julia responded to the question about what if the lactation room is a 7-minute walk away. The response was that the break wouldn't start until the individual reached the lactation room. Isn't this quite a slippery slope? When employees punch out for their lunch breaks, would that hold true when walking to their car to drive to a restaurant or to take a 5-minute walk to the cafeteria? That means their break or meal period didn't start. I really don't think so.
So you can look at the Department of Labor Standards Enforcement website. They have FAQs about break time and lactation, and basically it explains the net break time calculation.
Mm-hmm. Well, and I guess my understanding is, not being an attorney, is your lunch is unpaid. So you punch out for that because it's unpaid. Your break time, so the minimum is 10 minutes. Most people get 15 minutes. That you don't get penalized for where you're walking to take your break, to take that paid break time. Does that make sense? Understanding it in my lay terms, non-legal terms.
Yeah, rest breaks are different than meal breaks. Yes, in the way that you're required to be paid, and the way that they are required to give them to you. Meal breaks are sort of a different animal.
And if it's causing someone, stress over that in their job, I recommend that they talk to, if it's either HR or, a supervisor, to communicate what's happening, because maybe they need another space in another place of the hospital. Hospitals can be really big. And so maybe there's just a need for another space for people to access that's closer, in close proximity to their workplace.
Someone asked, someone asked, where can I see the PowerPoint again to review? So I'll go ahead and say that it's in the handouts right now. You can download it in the handout section, and then I'll also attach it, if I can, to the post-webinar email. Someone asked, is there a handout online where someone can print that explains the lactating breaks?
Yeah, we have a fact sheet on our website.
And you also have them in other languages. So I know on your website, when you click the language that you want to see your website in, then the handouts are, I believe, in those languages.
Yes.
Can an employer allow reasonable breaks of different lengths for different employees? Example, one employee for 15 minutes and another breastfeeding employee for 30 minutes to an hour. One reason being given is that it can take more time to pump if unsuccessful at first.
I mean, again, it's if that's reasonable, as long as it's not discriminatory in some way, and that's what's reasonable for the situation, then yes. You don't have to treat every person exactly the same when making accommodations for them.
This question is not exactly workplace accommodation related, but Robbie, you probably know where to find this information. It says, if you pump and had milk at room temperature, can it be freezed afterwards or frozen afterwards?
So if you have it at in a little cooler, you keep it cool at your desk, and then you take it home and put it in the freezer. Yeah. We always recommend the freshest milk first. So that milk that they pump today, hopefully then is used for tomorrow.
Last one, do you know the rate of employers that offer paid family leave, or FPL?
So the paid family leave program that I was talking about is a state-run program. So it doesn't come from employers. It's based on a payroll tax that employees pay automatically, through your paycheck. If you look at your pay stub, it has a deduction for California disability insurance. And so virtually, if you are paid in California with a paycheck and you're not a government employee, you are paying into that fund. So you are eligible regardless of the size of your employer, or, how long you've worked at that particular employer, as long as you have sufficient work history. So that should be virtually everyone. Again, not independent contractors and not some government employees, because they don't pay that particular tax. So almost everyone in California should be able to access that public paid family leave benefit. And the way that you would apply would be to go to edd.ca.gov. And the way that you could make sure you are eligible is to look at your pay stub. And again, in the deductions part, if it says CASDI, which stands for the California Disability Insurance Program, because it's the same tax that pays for both paid family leave and disability insurance, if you're paying into that and you've paid in for at least a minimum period of time in the base period and at least $300, then you're eligible for that benefit. In terms of the percentage of companies that, like private companies that just offer paid family leave as a benefit that like the company is paying for, it's about 14%.
That was the last question. So thanks to those of you who hung in there. About 3/4 of you did hang in there.
Yeah, and I just want to reiterate, I know this stuff is really complicated and it's hard to sort of simplify in all of these things. So if you have follow-up questions or if you're helping someone, you can call our Work and Family Helpline and an attorney will talk to you and help you figure it out. Even if it's not, it doesn't have to necessarily rise to the level of being a problem, right? Like we don't want the person to have been fired or quit or something because she can't get the accommodations. Like we would love to talk to you before that happens. So don't feel like you have to have absorbed all of this in this moment.
Thank you all so much, and thank you, Julia.
Yeah, thank you. I hope to hear from some of you soon.
Thank you, everyone.